Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. This episode of Slam the Gavel is sponsored by CPS Protect Consulting Services. A child protective services case is one of the most frightening experiences for any parent. Don't face it alone. Face it with confidence with Urgent Assist by CPS Protect. You can have access to former CPS investigators to make sure you preserve your rights and protect your family. If you're facing CPS involvement and aren't sure where to turn, their welfare consultants can help you. Visit cpsprotect.com/subscribe and enter the coupon code Slam the Gavel for 60% off your first year of Urgent Assist. And this is available in all 50 states. I have one more announcement. Bradley's mother, Narcissa Golan, passed away in the fall of 2022. Bradley is autistic and needs structured and routine therapies he receives for his autism 6 days a week. However, Italy just entrusted Bradley to Italian social services. If he is ruled to go back, he will face the next 3 to 4 years in the Italian foster care system where he cannot speak or understand the language. He will then be taken away from the only family he has ever known. Please call Governor Hochul at 518-474-8390, New York State. That's Governor Hochul at 518-474-8390. That's hashtag Keep Bradley Safe. And one last announcement, go to the site pleasedoyourjob.com. We need 2,500 more signatures to reopen a case. That's pleasedoyourjob.com. Super simple. I have a return guest. I'm so honored to have attorney T. Matt Phillips back on the podcast. He was last on season 3, episodes 137 and 152. He's got a brilliant, unique, one-of-a-kind class action lawsuits and includes a bunch of families. I think we're up to 11. Is that true? Or are you up to 11?
Yes, yes, approximately.
Oh, wow. Okay, so this all involves the Constitution, and you're going after the government.
Well, I mean, yes, the defendants. I can tell you briefly about the lawsuit. The name defendant is the Judicial Council of California, which is the policy-making body that trains judges. And essentially, the plaintiffs are arguing that there's no constitution in the California state court system, particularly in family court. They just don't recognize that the Constitution exists. And yet, the Constitution is supposed to be the supreme law of the land that is supposed to be paramount to everything. And yet, it's pretty obvious that in California courts that the judges, generally speaking, and the attorneys are just not arguing the Constitution. But my clients argue, of course, that parenting is a fundamental right. It's a constitutional right. It's protected by the 14th Amendment. And we believe that the judges in California need to be trained on this. That they need to know and understand that parenting is a fundamental right. So what we want to train them on is the judges to know and understand that parenting, first of all, is a fundamental right. And secondly, that they can't be taking away custody and they can't be taking away parenting time unless a parent is actually found unfit. And that's a big buzzword here. What does it mean to be unfit? Well, it's have to be some kind of evidence, actual evidence of child abuse, child neglect, child abandonment, child endangerment, but some actual evidence that is found in a fitness hearing, not in a divorce proceeding, but actually where the state of California brings a proceeding to allege somebody did child abuse or child neglect. If the state brings a proceeding alleging that a parent committed child abuse or child neglect, and if there's evidence and they're found to have done that, then yeah, you can take away somebody's custody rights. But just because that parent, I don't know, maybe they're stealing nachos at 7-Eleven, maybe they've done domestic violence to their spouse. A lot of them never seen a response like I have to this lawsuit, because I'm getting emails after email after emails, and the phone has not stopped ringing. And for all the people out there anxious to, ask questions, and I hope to get back to everybody, but it really has been, I'm really surprised. And
Well,
I knew people would find it interesting because it's such a different lawsuit. We're not suing the judges, which I believe is a strategic move to hopefully avoid some of the issues associated with immunity. Because if you sue a judge directly, it seems so often, even though I think there should be greater latitude in suing judges, one thing I've learned is that the courts seem to be predisposed against it, for better or worse. I think that's just a truism. So I think the idea of suing the Judicial Council as opposed to suing individual judges, I hope that's a strategic move. But the thing is also, I talk to so many people in California, and they have a bad judge, right? And they get rid of them. They make a 170.6 motion or where 1.1, whatever it is, to get rid of the judge. Well, they get rid of that judge, and they're every bit as dissatisfied with the new judge. And so the thing is, it seems like what's happening is that it doesn't even matter who you get. A lot of people think, well, Judge so and so is a strict judge and so is a more relaxed judge. There's, people get different feels for how judges may handle their docket and what have you. But the truth is, it doesn't matter which judge you get. They just will not recognize the constitutional parameter that you have to actually do harm to a minor child in order to lose custody of that minor child. And what I see happening is judges just exercising arbitrary discretion. Oh, somebody sent a moody text message, and they take away their kids, and they use temporary orders. And we all know temporary orders can't be appealed. And that's why they do temporary orders, but they're not really temporary in any kind of legitimate sense, because temporary drags on and on and on. I've talked to parents 2 or 3 years waiting for a hearing on temporary orders, and it's really unfortunate. I believe also on that issue, this is my philosophy: if an order contains an expiration date, then it could theoretically qualify as a temporary order. But if an order has no expiration date, there's no basis to say that's temporary. And I think that the people that are labeling these orders, I guess the judges that are labeling them as temporary, I believe it's awfully insincere, because a temporary order, I believe, by law, should have an expiration date, and ideally not more than 60 days out, because the longer it goes, the more, of course, permanent it has to it. But I think I'm going off topic here again.
Oh, no. On top of that is these judges aren't looking at evidence. I've talked to, I don't know how many parents, mothers, and fathers that the judge is not looking at evidence, and they're handing the kid over to the abusive parent. And they have and these parents have sent me the evidence of abuse. If I was a judge, I would probably get fired, because I would be actually looking at the evidence and taking too much time on the docket. But these judges, they're not doing their jobs by right to the child. The child has no rights.
Well, that's it really, I mean, I feel like I'm being very critical of the judiciary, and I think I think somebody has to say these things, because you got to ask. You said the judge's job. Well, really, what is the judge's job? My belief is the judge only has one job, and that's to protect people's civil rights, their constitutional rights. Yeah, the judge, I think, incidentally, has to decide the facts before them and decide the dispute. But I think fundamentally, the job of a judge should be to protect those federally protected civil rights, in the Bill of Rights. But what I see happening is that the judges have a conflict of interest, because the judges could be thinking, okay, do I want to protect the constitutional rights of these parents? Or if I create a non-custodial parent, then that's going to start the ball rolling. That's going to generate revenue. Just take the child away, and then the local district attorney is going to have to shake down that parent to collect child support, to send the letters and do all the stuff that they do. And of course, the federal government pays them to do this. And then when the non-custodial parent pays into the child support system, then the federal government rewards the state for collecting the money. And so basically the judge can benefit themselves and make more money for their employer simply by creating non-custodial parents.
Mhm.
And not only that, but you realize it's not just the act of taking away the parent, as you the custody time, but as you reduce a parent's custody time, the less and less and less it gets, then the more and more and more money for the state. So it isn't like they're going to take away the kids, take away just a little bit of your rights. They make it so you have no actual parenting time of any kind whatsoever. Then they want to bill you for the therapy, and they want to do the psych evaluations. They want everybody to take the drugs because everybody's going to be upset, and they need antidepressants. And of course, the pharmaceutical industrial complex wholeheartedly supports this kind of stuff. And it's really a snowball effect of spending money. But in my view, what should be happening is there should be 50-50 custody in 99% of the cases, because I would venture to guess that it's only probably 1% of the couples, the cases where one parent actually harms the minor child. It's probably a very, very low number. But in the vast, vast majority of all the other cases where you have two fit parents, those fit parents should be sharing physical custody 50-50, even Steven. And my argument for that one is simply the case of Troxel versus Granville, which creates what I call the Troxel fitness presumption. It says, and I quote, that this is a Supreme Court case. It says that fit parents are presumed to be acting in their children's best interests. Meaning, if you have two fit parents, even if they're not getting along and they hate each other, they're presumably both fit because they haven't been found unfit. And so these two fit parents should be deciding the best interest of the children. My belief is that the judge, and I know this is going to be scandalous when, the family court attorneys and practitioners hear this stuff, but in my opinion, the judge has absolutely no right to enter the private family realm. I'm quoting the case of Prince versus Massachusetts, a 1944 Supreme Court decision, which talks about, there is something known as a private family realm. And if you have two fit parents, why is the government trying to enter that situation? Because Troxel, in the 2000 Supreme Court decision, said fit parents are presumably acting in their children's best interests. So we don't need the government to come in and foist upon the children whatever that judge happens to think is in their best interest. And, one thing I hear all the time is the judge is really not acting in the child's best interest. They say they are, and it sounds glorious when they talk about, oh, we the children. I've heard these judges do these sermons about the best interest of the children and how they're going to protect the children. But I don't know, is it really in the child's best interest to have no contact of any kind with a loving parent? I mean, even if a parent has some flaws and they've done some things wrong, they should still be able to see their children. In fact, I want to bring up the Charles Manson thing. I know I've brought this up before, but remember Charlie Manson? He's 7 times he got convicted of 7 homicides, first-degree murders out in California. Charles Manson convicted of conspiracy to commit homicide. I mean, he's a serial killer. That's not a conspiracy theory. He is a known bad guy. And if you adopt the best interest kind of discretionary mindset, you could say, well, gosh, you know what? Because Charlie Manson had kids, you'd have to say, it's not really in the best interest of the children to be around the serial killer dad, right? Well, he never lost custody. Charles Manson never lost custody. And that's because he never did anything to the children. So why is it now that they're taking away parents? Oh, they're just doing it, I believe, to make money. And that's really a sad thing. And anyways, I know I'm going on a tangent here.
Oh, no, you're not. I mean, with the Charles Manson thing, I had just seen something where they're going to start, someone can quote me if I'm wrong, taking away a parent's right if they have committed a crime and they are in prison, they can't see their kids.
Well, yeah, I think that would be really wrong. I think that a child should be entitled to access to both loving parents, and we see a lot of the judges who are hypercritical about things like maybe the parent has alcohol in the house, or I don't know, tobacco or something, maybe they're not the best model parent in the world, but that doesn't mean they should lose custody, but I think it's also some of this may be attributable. I mean, this could be an hour-long deep dive, but the American mindset is built on competition. Americans inherently love competition. I think General Patton said that, and I think it's very
Yeah.
true. In America, we can turn singing and becomes a competition. Look at American Idol. It's not really art; it's a competition. And so, that happens in the family court. We see that competitive spirit where the parents are thrown into the Coliseum, so to speak, and the two gladiators have to fight it out. How does that really benefit the child? It doesn't. It does not benefit the children to have the parents constantly at war, but they want that because if there was no friction in the system, if it were a flat line market like financial markets, nobody earns money. But when there's roller coasters up and down, if you buy or sell on the right side of the curve, it's I'm philosophizing, but can I tell you how the lawsuit came into being, or how I
Oh, please, yeah,
came
please do. I'm sorry. Go ahead.
it came up because people want to know about the origins of this, that someone had asked me about the minimum wage, the federal minimum wage. By the way, do you know what the federal minimum wage is?
Well, it used to be $7 and something, right? Now it's 15.
7.25, I think it is.
Yeah.
7.25, I think. In California, it's $15.50. It's literally twice as high. And somebody had asked me, they said, you're always, talking out, because I'm always saying that federal law is paramount to state law. If you have a family code, like say California Family Code section says one thing, and there's a constitutional Supreme Court decision that says something else, well, that's going to be paramount. So somebody asked me, they said, how come it is that the federal government sets the wage at, I guess, $7.25 an hour, but California sets it at $15.50? Isn't the federal law paramount? I said, well, yeah, it is, but that federal law is a minimum wage. And that word minimum, I'm being Austin Powers here, right?
Yeah.
But the minimum is significant. That's the minimum they can pay you. The point is, states can give you a higher minimum wage. I think in Nevada, I think it's $10.25 an hour in Nevada. But the point is, states can give you more rights as a worker. They just can't give you less. And that's a theme that I wanted to center on here. States can give you more than the federal minimum, in this case, wage, but they can't give you less. And then this comes up in other contexts too. Look at the idea of freedom of speech, okay? People think freedom of speech comes from the First Amendment, and it does to a large degree. But look at the First Amendment. The first 5 words of the First Amendment are Congress shall make no law. Those 5 words are prohibitory in nature. They really speak to what the government can't do. The First Amendment really doesn't necessarily empower people, but if you look at the California Constitution, it has a free speech clause in the California Constitution that basically says all persons have the right to freely speak and write and publish their sentiments on all subjects. I think I got that right.
Mhm.
But they can freely speak, write, and publish their sentiments on all subjects. That actually empowers you. And I've had First Amendment cases where I like to argue not necessarily the First Amendment from the federal Constitution, but the California state Constitution, which I believe gives Californians more free speech rights. And again, we see this doctrine playing out where the federal law sets the minimum bar. Congress shall make no law. But California can empower people and give them more free speech rights. And this comes up, there was a third example. Oh, the ADA. You may remember the Americans with Disabilities Act. This was 1991 that Bush the first had signed. And basically, the ADA, the Americans with Disabilities Act, sets the minimum federal bar, the minimum amount of access rights for disabled people. Now, in California, they have their own ADA. There's actually a California version of the ADA. And as you may have guessed, California ADA gives you more rights, gives more access to disabled people than does the federal ADA. So the point is here, we see over and over this doctrine that the federal law sets the minimum. You can't go below that, but states can give you more rights. Now, why am I saying all this? Because look what's happening in California state courts, particularly family court. What's happened is that I believe there's a minimum federal bar out there that says parenting is a fundamental right and you have a right to be a parent unless or until you've been proven unfit. I believe that's what the law is, but they're taking away the fundamental right to parent for a lot less. And so what I see happening is, constitutional violations en masse going on in California, where as a general standard, the judiciary in California has dropped below the minimum federal guarantee. And again, states can give you more rights, they just can't give you less. And I anticipate the attorneys for the state of California in this case are going to be arguing that they have the right to set the policy and they're the sole decision makers. And again, I agree with that. But that being said, they've allowed the standards to fall below the minimum federal guarantee, which says you have a right to actual parenting time, a right to bring up your children unless or until you've been found unfit. And again, when I say unfit, I don't mean the other side is, hollering allegations at you. I mean unfit because the state of California brought a proceeding and they demonstrated with clear and convincing evidence that you committed child abuse. In that case, I say, yeah, take the custody away. But until that day happens, people should be with their kids. And what's happening is this is creating a devastating effect, I believe, in California. They're ruining families. They are ruining people's lives. And we really don't even know the trauma, 20, 30 years down the road with some of these children. And, one of the things I was thinking about in our lawsuit, we estimate that approximately 100 California children lose a parent every day that the court is open for business. And that's a frightening number. Just think about when you were, 8, 9 years old. I remember as a kid, my worst fear was you losing mommy and daddy when you're, a young. And yet we do it all the time. Is that really in the child's best interest to rip away their kids? And then, the only way you can see them is at reunification camp, which is horrible in itself because the child gets the impression that the non-custodial parents are somehow a criminal, and certainly I go far afield here, but that's another people. Some people have been asking, why didn't we put the criminal element into this lawsuit? What I mean by that is another big problem with the California courts, particularly family court, is that they allow criminal allegations in the family court. And my belief is that criminal allegations have no place because once you start making criminal allegations, it becomes a criminal proceeding. And the court should be instituting the constitutional safeguards and procedures, Fourth Amendment, Fifth Amendment, Sixth Amendment, speedy trial, the right to appointed counsel, the right to have a presumption of innocence, the right to not incriminate yourself, the right to object when they want to do a mental health evaluation. You should be able to object and say, Fourth Amendment, where's the probable cause? You have no right to do a mental health evaluation unless you come back with a warrant supported by probable cause. These kind of arguments should be made, but a big problem I think with the family court is the way they allow essentially one parent to be a private prosecutor, vigilante justice. We allow one party to be the prosecutor and the victim at the same time. And
Oh, yes.
that's we tried that in America like a couple hundred years ago. It didn't work out because it's inherently unreliable to have the person giving evidence also being the victim and also prosecuting the matter. And then, of course, there's no jury. This is another problem. And once there are criminal allegations, the appropriate evidentiary standard should be the highest one. It should be beyond a reasonable doubt and to a moral certainty. But they're using lower evidentiary standards to conclude that people are committing crimes. And when you criticize the practice, it's funny, but the people who work within the system, they defend it by saying, well, it's not really criminal because we're not trying to put you in jail. It's just like civil, equivalent. But it's really, the point is, the Supreme Court has already said that a proceeding becomes a criminal proceeding when you introduce criminal allegations. And I think that's so I did want to say that about the whole criminal dynamic, because I thought it'd be good that the viewers hear this, but it's not in the lawsuit, because the lawsuit focuses specifically on the fact that California judges need to be trained, A, that parenting is a constitutional right, and B, that the Constitution forbids the taking away of all those parenting rights absent a showing of unfitness.
I'm sure, like you said, you've got a boatload of parents calling you. I'm sure, like when you, with these cases, you amend them here and there. Are you going to be amending this case, changing things around in it shortly?
Well, there were a couple of people that really wanted to be in the lawsuit and as a named plaintiff, and so we also wanted to add some additional allegations. We had the first lawsuit out there, and there's been so much feedback that I wanted to tweak a couple things to make them more crystal, and the amended complaint is going to be hopefully served tomorrow on the defendants. But let me say this. Everybody who wants to participate as a class member certainly has a right to do it. I believe the lawsuit will be successful. I mean, it remains to be seen, obviously. But if we are, I'm anticipating they'll file a motion to dismiss. Assuming we were to survive a motion to dismiss, I imagine there will be a class certification motion where we will allege there's a class of people, and we're going to identify that class as any person who has not been declared unfit and yet has no actual parenting time, meaning no care, custody, and control of their children, and no private speech. They've basically been eradicated. They've basically been constructively terminated, although everybody seems to be shy of using that word, but that's, I kind of think, the stark reality. If you have no care, custody, and control, and no private speech, you've been terminated. The parent-child relationship has been severed. And basically, the class would consist of all parents in California who have not been declared unfit and yet have no actual parenting time with their children. And we are wanting money damages. We want to get monetary compensation for each and every day that the parents were wrongfully dispossessed of their parental rights. And we believe that the children should receive a like sum of money. Because remember, these rights are to a large degree mirrored almost entirely. And we talk about the right to parent, and yes, we have a constitutional right to parent, but the children also have a constitutional right to be parented. And you never hear people talk about that. And the big thing that's going to be the issue, I think, in our case, is there's two philosophical belief systems that are going to come into clash. I'm sure that the state, or at least I'm not sure, I don't know, I'm imagining the state is going to be arguing the best interest standard, and that all the judges act in the best interest, and we can't question they do. As long as they tip their hat to best interest, they can pretty much do whatever they want. I disagree with that, but there are a lot of people that really think the judges are acting in the child's best interest. But I think there's legitimate room to disagree with that. And in any case, I don't think that the best interest standard is appropriate. First of all, because the judges shouldn't be exercising best interest. particularly if you have two fit parents. Because if you have two fit parents, they are presumptively acting in their children's best interest, and the state has no business entering the private family realm. Again, that's the Prince versus Massachusetts case. So I think I lost my point here, but anyways, what's going to happen is we have our definition for what we think is a class, and I'm sure the other side will say there's not a class and the facts are too disparate, you know. But if the court certifies a class, then everybody can join. Everybody who is fit and yet has no actual parenting time. And I suspect the numbers will actually be staggering. You know, and I was saying in the lawsuit, we estimated it's about 100 children per day. I think there's an argument it could be as high as 400. You know, we really don't know. That's why I put it as an estimate. But, you know, in discussing this with people and trying to come up with what would be an estimate, it really made me think, like, why are they not broadcasting this? You know, government has statistics. Here's how many school books we print. Here's how many, you know, the government made this many cars in California. You know, we have this many LED light bulbs now, whatever they, you know, want to brag about. Why is there no statistic about how many children have lost a parent? Like, why are there no numbers on that? And I want to take discovery. I want to know what is the numbers. And you know what I think we need to do? And this would be like a kind of like a PR move, I guess. But you know how they have the debt clock, United States debt clock? It's like 47 trillion gazillion dollars, and the wheels are spinning on the, you know, the numbers, because the debt is always going up. We need like a child custody clock in California. Every time a child loses a parent, bing, bing, bing. I mean, I have a feeling it would be just ringing off the hook. And when people realize this, it's kind of a scary thing, because some estimates are that 90% of the couples in California, somebody loses custody, you know. And just think, like right now in Los Angeles County, I would imagine there's probably 10,000 cases that may be filed in the next month. And of those 10,000 couples that are out there, you mean to tell me that 9 out of 10 have dysfunctional parents that shouldn't be with their children? It just seems inordinately high. But then again, you know, I believe the reason they're doing this is because they make money. The judge can literally make money for their employer. And why are the attorneys not arguing conflict of interest on this? I don't know. I think someone should argue it, you know, and I want to make these arguments because I think, frankly, I think it's that important. You know, I'll say another thing. Somebody was telling me, I know I'm kind of rambling here, but they mentioned the Family Law Act that Ronald Reagan signed. I think it was like 1969 or something, and how it got rid of fault. Like, Americans decided we want no fault divorce. Couples, it doesn't matter who cheated, who did what, you know, they just want to get it over with. They want to move on. And that's how, you know, Nevada made a fortune, being the divorce capital of the world. Get a quickie divorce, get in, get out, you know, and it's a no fault system. But what has happened in the last 20 years is the attorneys have they brought fault back into the system. It's all about fault. It's all about getting sanctions and attorney's fees because you filed an ex parte motion. The whole thing is generated by fault, because fault creates attorney's fees. Fault will keep the money going. You know, and another thing I believe in family court, how do they have prevailing parties in family court? You know, if somebody sues for breach of contract, either that person is going to win on the breach of contract claim or they're going to lose. Either they prove it or they don't. Because in civil court, there has to be a winner. Somebody got to win, somebody got to lose. What about family court? Well, there shouldn't be any winners or losers. Now, I know that sounds like a country western song, but there shouldn't be any winners or losers, because the petitioner who's petitioning for dissolution or for custody, the point is you go to family court to divvy up assets and divvy up custody time. Nobody's there to win. You're not there to allege wrongdoing, because wrongdoing should not be alleged in the first place. because it's a no-fault system. So wrongdoing is irrelevant. But the family court bar, of whom I'm very critical, has decided, let's bring fault back. Then we can have prevailing parties and somebody can win on their divorce case. How do you win a divorce case? I mean, arguably, you may get what you want out of the divorce. You get the result that makes you happy. But how do you win? How did you prove your case? Did you prove that you were married and now you prove that you shouldn't be? I mean, and I'm getting philosophical here, but anyways, that's my story and I'm sticking to it.
No, I think that is absolutely brilliant to come up with this. Because, with the 50-50, I think, they should just repeal the Title 4D. And that way, have both parents work together and co-parent if you can. It's hard because people say, well, I can't co-parent with my abuser. I mean, I couldn't either once he turned into that. But, somehow people have got to be able to financially work this instead of making one person a slave.
Or paying into the system, The thing is, we don't need all this money paid to these family court lawyers. And another thing I got to tell you, I found is I've been, I don't really practice family law, and I'm certainly not a family law specialist, but I've been helping out some people in California, friends and what have you. And I'm shocked at what I see, because when I get people or people want me to represent them, I get so many calls, and they tell me about their lawyer that ripped them off and I paid them $60,000. They didn't file anything, I mean, I've heard that story so many times. They're paying obscene amounts of money. If I do, I don't know, say I work with some company and I'm doing music licensing or copyright, I'm going to charge a fixed sum of money depending, but when it comes to family court, it's like, oh, really? Let me see your FL 150. Let me see your, your financial disclosure forms. The question always comes up. It's funny. How much does divorce cost? Well, how much you got? If your net worth is 300,000, divorce will cost 300,000 because the attorneys know how much you got, and the attorneys, from what I've seen, are literally working in collusion. It's crazy, and I could tell you stories that would curl your hair. What a lot of these attorneys are doing, it's really, really bad. And the worst part is when somebody complains, everybody looks at the parent like, well, that's just a high conflict thing, and the parent really is just upset, and they're not taking responsibility for their actions. They have all the gaslighting comebacks ready. But the point is that there shouldn't be attorneys in the first place. There really shouldn't be attorneys in family court. They should outlaw the attorneys, in my belief. And they should walk in there and people fill out the forms, and the judge should say, we are here to do two things. We are here to take inventory of everything you own and split it down the middle. What we can't cut in two, we're going to sell and split the proceeds, And when it comes to the kids, 50-50 custodial time, because all parents are fit, and that are fit are presumed to be acting in their children's best interest. Why do we need to do mental health evaluations and reunification camps and evaluators and custody evaluators? And, it's insanity. It's absolute insanity what it's turned into. But
Well,
anyway, are we at time yet? Or
oh, no, we're fine. No, I was going to ask you, because with the personality disorders out there, and I think they have tripled in the last 10 years, we'll say. So this is what also keeps these wheels oiled quite nicely in the family court machinery, is these personality disorders that will just call out, oh, he or she is mentally ill. And we'll just say, like for instance, in my case, they said that I was wearing wigs. Okay, so the reason why I was wearing wigs, I'm telling everybody right now, see how my hair is all curly and weird? So I would buy wigs with straight hair. So, you don't have to damage your hair. You can just throw a wig on and you'd have straight hair. But somehow that made me crazy. Yeah. So I had to have a psych eval, which was pristine. And the psychologist even came, which I was surprised. He got on he got on the witness stand. He totally demolished the other side because they brought up the wigs. And he says, oh no, wigs are a lucrative industry. You know, you've got entertainers wearing wigs. People are, you know, wearing them every day, you know, either, you know, if they have cancer, if they're in the entertainment industry, there's a multiple reasons why people wear wigs, to hide their identity, to whatever. So, you know, and as far as his concern with me was that I just like to wear wigs to, you know, be different and or straighten the hair.
Well, I would tell everybody, just as a friendly advice, don't ever do a mental health evaluation because it's a losing battle. They're going to find something wrong. And then when the person protests, I'm not crazy, they're going to say, well, come on, you must be. You're going through a divorce. It's got to be, you're going to have the blues. You're going to be depressed. You need Prozac, Schmozac, and everyone goes along with it because, of course, you're going to be that way. You're in the middle of a family court dispute. But the point is that none of this stuff should matter. It's all, you know, one thing I really am critical about the state also is they're always the best interest, the best interest, the best interest. And, you know, someone called me, I've heard this sentiment so many times. You know, the CPS comes to their house and their house is spotless, it's beautiful.
Yep.
There's no problems. They pass with flying colors. But the next door neighbors got kids running around with no clothes and peanut butter in their hair and playing with dangerous stuff, you know, and running in the street, and there's no parents in sight. And the point is that if the state were really concerned about children, they would enforce it universally on all parents. But it's almost like they take the opportunity to because you're trapped in family court. Now they got you, and they're going to do all the testing and the evaluations and this and they'll spend money on that, and then the unified therapy and the therapy this, and then make you spend money on that, and then you got to pay your children for the supervised visits, and you got to pay for the supervised visitors. You know, at some point, like that's the problem with all this family court, and it's got to end. And I'm hoping that my big hope is that the mainstream media will chime in on this. And of course, the mainstream media doesn't, because the mainstream media, as you know, is owned by the pharmaceutical industrial complex. And we know that because every commercial is, you know, Windex, Tide Pods, Febreze, all the things we use that are chemicals on a basis. And so they decide what goes on the airwaves. And America is just not ready to learn that there's a Holocaust going on in our backyard that nobody's willing to talk about. And God forbid some parent does, well, he's crazy or she's crazy, you know, and they're a disgruntled parent and they're vexatious and gaslighting. So I'm hoping the mainstream media, I'm actually very hopeful because I have gotten so many inquiries and I've done interviews with people, and hopefully the word will get out there. So
I think it will. And I'm so glad I had you on. I'd like to have you back on again. I know you don't want to hear this, but how can people reach you if they have any questions?
Well, actually, I got to say, it's been so crazy. I would say the email address, which is my name, T. Matthew Phillips, all one word. There's no periods or spaces or underlines. Just T. Matthew Phillips at AOL.com. Once again, that's T. Matthew Phillips at AOL.com. And it's been about a week since we filed, I guess 8 days since we filed, and I still haven't got back to everybody. It's been that much of a, you know, but I do hope to get back to everybody, and I'm going to create a mailing list for contacting those people that have contacted me. And so I hope to answer everybody's questions, basically is what I wanted to say.
Oh, that's excellent. Well, if you had any advice to give any of these parents that are contemplating divorce, what would you tell them?
Don't do it. Come up with a solution out of court. I mean, because it's, you know, it's a non-win situation. And I think one of the problems with family court is that there are some bad parents out there, but sadly, those are the ones they give custody to. I mean, I really believe that these judges, they know the more diligent parent. They know which parent is more competent, which parent is more capable of putting up a fight. that's the one who's going to lose custody. And the one who's maybe not so mature, they tend to give it to the worst parent. And that parent suddenly like, yeah, I'm the better parent. I won. And that parent who won, their ego is going to tell them spend every last dime to remain in the number one position. The parent who's non-custodial, well, they'll spend their last dime just to see the kid. The point is, don't go to family court. That's got to be the worst thing in the world. And because you know why? When you go to family court, you're really giving your child to the state. You are delivering up your child on the sacrificial altar of the state. And now both parents are fighting to get the kid back because you've given that child to the state. And all of a sudden, the judge believes that my discretion, whatever I come up with in terms of best interest, is going to supersede the parent's best interest. Parents, you don't get best interest anymore. I've got it all. You've given me the kid, and I've got the best interest power. Well, again, that's wrong. If you look at the constitutional decisions, the best interest resides with the fit parents. And so, anyways, I'm probably repeating.
No, you're not. That was very profound. I like how you worded that. But hey, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I am your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth, and the recently released Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. You can find me on Spotify, YouTube, Apple iTunes, Anchor FM, iHeartRadio, and please feel free to donate to buy me a coffee to keep the podcast going. And thank you, attorney T. Matt Phillips, because you are coming back on.
Rock and roll.